Okay, here's a court document that was filed yesterday from the Idaho Supreme Court decision about the gag order. Okay, the Supreme Court here that all these people here filed, which we pretty much knew. And Bryan was there and spoke on his own behalf, of course. And I'm not going to read all this word for word because it's mainly case law. And they also talked about the first previous meetings about the gag order. Okay, so I'll just read, like nature of the case. Petition by various media company to this court to grant a writ that would dissolve the gag order. The media main contention is that the district court should have held a hearing and taken evidence to enter the gag order. Bryan Kohberger appears now to argue on his own behalf that no such hearing is required to enter an order that merely reflects long-standing rules of professional conduct, and that no comment order in this matter is appropriate. Okay? And then they talked about the dates that all these other filings were. Okay, December 29th, first degree murder, the 30th, limited appearance, January 3rd, entry of the gag order. And then we know what was said about the gag order here, that nobody can talk, attorneys, the families, um, law enforcement. So we already knew about this, okay? On the 13th, a Zoom meeting with parties was under seal about the gag order. On the 18th, let's see, contained a preference indicating law perverts of the entry of such an order. The parties stipulated to this entry and added the attorneys for witnesses, victims, victim families bound to this order. And then there's that. Okay. February 3rd, an attorney for the victim's family filed a motion, which we know about. February 6th, petitioners filed request to dissolve the gag order. On February 28th, the court unsealed the memorandum with redactions of the January 13th meeting. Okay. Petitioners should have filed a motion to amend the gag order before seeking this relief. District court was required to hold a hearing or make findings before entering a gag order, purely attorneys or agents, law enforcement. District court required to hold a hearing or make findings before entering a no comment order involving attorneys, law enforcement. Okay, introduction. At issue in the petition whether the magistrate erred by not holding a hearing and applied the wrong standard when granting the gag order. This is not appropriate order to wit mandamus or writ of probation. Petitioners can and have just recently in other cases appeared at trial court level and made the arguments in proper forum. There is nothing in the record to show that they have done this, attempting to be heard by magistrate court. This court shall not permit the petitioners to turn into the court of first resort for First Amendment litigation. And then goes into case law, all these case laws. Okay, I'll read this though. Petitioners in this matter have argued that there's no way for them to seek relief of the gag order because there's no way to intervene. However, here they bring up Daybell case. Many of the same media corporations all appear to be on both cases. There are possibly more media corporations that took part in both cases, given the way the media groups are named seems to be differ slightly. Petitioners in this file filed a interested person's response to a defendant's motion to clarify media in the courtroom. Okay. District Court in Daybell case indicated that the media had been permitted to participate in filings, and then media denied the request. Okay. It makes no mention of this. Rather, it indicates that intervene in a criminal case is not provided by the rule. While true, that hardly prevents the petitioners from filing a motion as interested parties before the district court in the case below. Okay, so it talks about these other cases. Okay. Let's see. The courts of the state have never been stingy about permitting the media to argue on behalf of the public access. The media also claims it has not had an opportunity to lodge a written or oral obligation. There's no indication in the record they have even tried in the case below. It is rather odd to claim a lack of opportunity to challenge an order that has already been amended once and can entirely be amended again. As we will be examined below, what the media really seeks here is prejudicial victory, knowing full well it cannot win on the merits of any test. Given the persuasive and grossly twisted nature of the media coverage that has occurred thus far, the media has never attempted to appear before district court, provides this court with no record of what claims that has gone wrong. Thus, it wishes to argue, oh boy, they're not happy. It wishes to argue that they had to be a record of what's gone right. But the questions of whether the district court made an error in entering these orders is far from appropriate target for this. This is simply an appeal from an order of the media did not take part in. Petitioners have claimed that the gag order in this matter violates First Amendment, but focus their argument on what standard applies to the gag order. Petitioners then, I don't know that word, treat every case alike and argue in favor of scrutiny, and claim that the order in this case would not survive any scrutiny even if they accept the part of the order that does nothing that the rule of professional ethics do not already do. Petitioners have failed to show any error in the right of the remedy. Okay, I'm just skipping through a lot of this, people, because of the case law. Petitioner claimed that strict scrutiny inappropriate for gag order for attorneys or agents has no basis in law. Instead, petitioner cherry-picks quotations from cases that pointed do not require scrutiny. Okay, see, more case law, people. Okay, it says here, the first part of the amended or gag order prohibits essential any speech concerning the case and sometimes termed no comment order. The issue is with an order who entered indeed may be reasonable. The question is whether the court properly entered the order and applied for the governing law. The media insists that the record does not show that the district conducted a hearing before the order. The court is aware that the district court had a duty pursuant to the, here we go, the rules. Okay. Moreover, it has a duty to safeguard Mr. Kohberger's right to a fair trial. Thus, the district court is aware of conduct concerning the behavior of attorneys in this matter. It has a duty in order to correct misbehavior. Ooh. The media seems to argue that the district court should have included at least a summary of the news stories that caused it to deem the no contact order necessary. If this was an appeal, it would be tempting to agree. However, this is a petition of right of mandamus. The matter is only 2 months old. As noted in the first section of this brief, the media has the ability to request the gag order amendment or at a magistrate level. In this case, the record makes it clear that district court was responding as it required to do for purpose of due process to the media coverage on this case. Even the magistrate court went too far. That is something that the best addressed at the trial level. The court should not simply dissolve the protection put in place for Bryan Kohberger. And here's the conclusion. It was denied.